Hello, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thank you for joining us. Hey, today I thought we'd spend a little bit of time talking about a fairly complicated piece of legislation as written. And it's important to all of us, especially us parents out there. So let's talk about what are the laws regarding weapons on school facilities in Washington State. Okay, before we get rolling, you guys know the drill. If you like this video, go ahead and click that like button down below. If you want to stay up to date on issues related to your Second Amendment rights, go ahead and click the subscribe button down below. Click the little bell logo down below if you want to be notified. And a couple things. One, please keep the comments coming. The more we comment, the more we talk about these issues, the more the YouTube algorithm is going to get our video out to more lawful and responsible gun owners. Secondly, we're thinking about doing a once a month live open discussion where you guys can log into YouTube Live and talk with me about issues that you may have, scenarios that you may want to go over. So if you're interested in that, we're kind of trying to take an informal poll here. If that's something you'd be interested in participating, please go ahead and comment down in the section below. If we get enough interest, we'd love to do that for you. Okay, so the issue that we're going to be talking about today is weapons at school facilities. Now, in a general sense, and we all kind of know this, that schools are considered gun-free zones. What is a gun-free zone? Well, to refresh our memory, a gun-free zone is an area that the state legislature has mandated that there will be no firearms at, and they have done so through enactment of an RCW. When we're talking about school facilities, the statute that we're going to be spending time today talking about is RCW 9.41.280. Now, the interesting thing before we get into the statute is understand, unlike private businesses, which can restrict firearms on their premises as a condition of doing business with them, if you violate a gun-free zone, that is, you take a firearm into a place which by statute it's prohibited to be, you are looking at serious criminal sanctions. So, a word to the wise, part of being the lawful and responsible gun owner is we never take firearms into gun-free zones. Okay, so the statute that we're going to be talking about today is RCW 9.41.280, and in typical fashion, as you can see, the legislature has gotten way, way wordier than they probably needed to be. So we're going to have to take this statute section by section, dissect it, digest it for you, wrap it all up, put a little bow on top so all of us can really understand what are the laws regarding weapons on school facilities, what are our rights, what are our obligations, so we can continue to be lawful and responsible gun owners. Okay, so let's start right at the very top and find out what exactly does this statute tell us, what is prohibited on school facilities. Well, the statute reads as follows. It is unlawful for any person to carry onto or to possess on public or private elementary or secondary school premises, school-provided transportation, or areas of facilities while being used exclusively by public or private schools, A, any firearm, B, any dangerous weapon as defined in RCW 9.41.250. And as we go back and we take a look at RCW 9.41.250, and we'll put the link for a video we did about that, we know that dirks, daggers, sand clubs, metal knuckles, all of those weapons are considered to be unlawful weapons under RCW 9.41.250, and therefore under 280 are prohibited on school grounds. The statute goes on to further define other items which are unlawful, including C, any device commonly known as nunchuck sticks, consisting of two or more lengths of wood, metal, plastic, or similar substances connected with wire, rope, or other means. And some of us are familiar with nunchucks. It is a martial arts weapon made famous by Bruce Lee. Those are illegal on school grounds. The statute further states, any device commonly known as throwing stars, which are multi-pointed metal objects designed to embed upon impact from any aspect. E, any air gun, including any air pistol or air rifle, designed to propel a BB, pellet, or other projectile by the discharge of compressed air, carbon dioxide, or other gas. Or F, any portable device manufactured to function as a weapon, which is commonly known as a stun gun, including a projectile stun gun, which operates wired probes that are attached to the device that emit an electrical charge designed to administer to a person or an animal an electric shock, charge, or impulse. Or 2, any device, object, or instrument which is used or intended to be used as a weapon with the intent to injure a person by electric shock, charge, or impulse. So as you can see from this statute, RCW 9.41.280 outlaws a lot more than just firearms on school grounds. Nunchucks, throwing stars, all the weapons listed in RCW 9.41.250. Any object which is really designed to be used as a weapon. Any air gun, BB gun, pellet gun, airsoft rifle, any of those. All of those are prohibited on school grounds. Now, what happens if you're found in violation of this law? Well, the law tells us as follows. Any such person violating subsection 1 of this section is guilty of a gross misdemeanor. If any person is convicted of a violation of subsection 1A, that would be a firearm on school grounds, the person shall have his or her concealed pistol license, if any, revoked for a period of 3 years. Anyone convicted under this subsection is prohibited from applying for a concealed pistol license for a period of 3 years. The court shall send notice of the revocation to the Department of Licensing in the city, town, or county in which issued the license. Any violation of subsection 1 of this section by an elementary or secondary school student constitutes grounds for expulsion from the state's public schools in accordance with RCW 28A 600.010. An appropriate school authority shall promptly notify law enforcement and the student's parents or guardians regarding any allegation or indication of such violation. So, if you are found in violation of this law, you are facing a gross misdemeanor, which is, as you know, punishable by up to 364 days in jail and a $5,000 fine. If you are a student found in violation of this law, you not only are facing potential gross misdemeanor charges, now granted that may be in a juvenile court, and the sentencing scheme under RCW Title 13, the Juvenile Justice Act, is far different. We're not going to get too far off course today. But not only are you facing criminal charges, you are almost assuredly facing expulsion from school. But here's what else you need to know, especially if you have children. And that is, if the offender here is 12 years of age or older or under the age of 21, there is a significant crisis response mechanism in this statute, which is automatically taken into place, which you need to be aware of. It reads as follows. Upon the arrest of a person at least 12 years of age and not more than 21 years of age for violating subsection 1A of this section, again, that is the firearm on school grounds, the person shall be detained or confined in a juvenile or adult facility for up to 72 hours. The person shall not be released within 72 hours until after the person has been examined and evaluated by the designated crisis responder, unless the court in its discretion releases the person sooner after determination regarding probable cause or on a probation bond or bail. And then the statute further states, within 24 hours of the arrest, the arresting law enforcement agency shall refer the person to the designated crisis responder for examination and evaluation under Chapter 71.05 or 71.34 of the RCW, and inform a parent or guardian of the person of the arrest, detention, and examination. The designated crisis responder shall examine and evaluate the person subject to the provisions of Chapter 7105 or 7134. The examination shall occur at the facility in which the person is detained or confined. If the person has been released on probation, bond, or bail, the examination shall occur wherever is appropriate. And just for further reference, 71.05 deals with all of our mental health treatment rules. 71.34 deals with mental health treatment issues for those who are minors. So, let's go back over things. We know that we cannot possess firearms, nunchucks, throwing stars, any of the weapons found in RCW 9.41.250, daggers, dirks, metal knuckles, sand clubs, any of that. We also know that we cannot possess anything which is designed to be a weapon. We cannot possess any air rifle, air gun, BB gun, pellet gun, or anything like that on school premises. We know that if we get in trouble and we're 21 or older, we're looking at a gross misdemeanor. We know if we're between the magical age of 12 and 21, we're going to be taken into custody, we're going to be held in custody, and we're going to be subjected to a mandatory mental health examination. Is that the end of it? No, of course there's more. There are exceptions to this statute, and for the lawful and responsible gun owner, this is the part that we need to be really aware of. When can we actually take a firearm onto a school ground? Because believe it or not, RCW 9.41.280 actually does provide instances in which it is lawful to have a firearm on school grounds, and they include as follows. Subsection 1 of this section does not apply to A. Any student or employee of a private military academy when on the property of the academy. B. Any person engaged in military, law enforcement, or school district security activities. However, a person who is not a commissioned law enforcement officer and who provides school security services under the direction of a school administrator may not possess a device listed in subsection 1F of this section unless he or she has successfully completed the training in the use of such devices that is equivalent to the training received by commissioned law enforcement officers. And again, section 1F is our stun guns, our tasers, and all of that stuff. So you have to have very particular training if you are allowed to carry that by the school district. Now, there's other exceptions in the statute, and they include the following. C. Any person who is involved in a convention, showing, demonstration, lecture, or firearms safety course authorized by school authorities in which the firearms of collectors or instructors are handled or displayed. D. Any person while the person is participating in a firearms or airgun competition approved by the school or school district. And I would say that the likelihood, especially in the public school system, that we're going to have any competitions, displays, or otherwise involving firearms is virtually impossible in this state. Now, we're about to get to a couple of very important exceptions, ones that are most likely going to apply to you, the lawful and responsible gun owner, and they include the following. E. Any person in possession of a pistol who has been issued a license under RCW 9.41.070 or is exempt from the licensing requirement by RCW 9.41.060 while picking up or dropping off a student. And this to me is the most significant exception because it is the one that we are most likely going to have to encounter. So if we are validly licensed with the CPL, and we are carrying it consistent with RCW 9.41.050, 060, 070, and 060 is the statute that exempts certain people from having to have a CPL in order to carry concealed. But as long as we are carrying consistent with the law, and all we are doing is dropping off or picking up the kids at school, that is not unlawful. There is one other very important exception which many of you may encounter, and it is as follows. F. Any non-student at least 18 years of age legally in possession of a firearm or dangerous weapon that is secured within an attended vehicle or concealed from view within a locked, unattended vehicle while conducting legitimate business at the school. So if we are conducting legitimate business in the school and the firearm is in the car with us at all times, or if we leave the firearm unattended but it is secured and concealed from view, consistent with RCW 9.41.050, and we're at least 18 years of age, and candidly, a pistol requires a person to at least be 21 years of age under Washington law, that is an exception to the statute. Now, as a side note, I do drop my kids off at school, and I always have a firearm in my vehicle. I drive onto school property, they get out of the car, I drive off school property. The firearm is in my vehicle at all times, but there is nothing unlawful about that. I have also had the pleasure of conducting business at school. I've had the pleasure of teaching young people about civics and constitutional law and things like that. And yes, when I parked the vehicle on the property, the firearm was secured in my vehicle, concealed from view, and accessible only by me. I did not take the firearm in the school with me because I was not concerned. I did not need it, and candidly, I didn't believe it belonged in there. And then, of course, there is one last exception, and that is found in subsection H, which reads as follows. Any law enforcement officer of the federal, state, or local government agency. So law enforcement officers are obviously allowed to carry their service weapons onto school property. Now, there are some other exceptions in the statute for some of the martial art weapons if they are being used in actual martial art classes, displays, to be talked about from a historical perspective. They are also allowed on school grounds. So, when we take this big convoluted statute and we break it all down, what did we learn today? Well, we learned that firearms are not allowed on school grounds under any circumstance except for the exceptions of dropping or picking the kids up from school or being secured in an automobile by someone who's proper age who is otherwise conducting lawful business on the campus. We cannot possess most martial art weapons, including nunchucks, throwing stars. We cannot possess daggers, dirks, sand clubs, metal knuckles, or anything listed in RCW 9.41.250. We cannot possess tasers, stun guns, or anything like that, and we cannot possess air guns or BB guns, pellet guns, or anything of that nature. Listen, you may have more questions about what you can or cannot carry onto school property, and if you do, that's fine. Don't ever hesitate to contact us at WashingtonGunLaw.com. Or, of course, you can call us directly at 425-765-0487. I want to hear from you guys again. If you are interested in doing a live chat once a month, let me know in the comment section down below. Listen, part of being the lawful and responsible gun owner, like we preach all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.